Hello, I'm Stuart Berman. I'm a principal in the litigation group at Lerch, Brewer. Before going into private practice, I clerked for a federal judge and then spent 28 years at the Department of Justice, including 23 years at the United States Attorney's Office here in Maryland. Prosecutors in that office generally handle their own appeals in the United States Court of Appeals for the Fourth Circuit in Richmond, and I've briefed and argued dozens of cases there. As a prosecutor and as a private attorney, I've also worked on criminal and civil cases in the U.S. Supreme Court and in federal appellate courts around the country. I currently have cases in the Fourth Circuit, in the District of Columbia Circuit, and in the 11th Circuit in Atlanta, and I recently argued a case in Maryland's highest court, the Supreme Court of Maryland.
Hi, I'm Trish Weaver, also a litigation principal at Lerch. After clerking for a judge on the Supreme Court of Maryland, I joined a firm in Montgomery County in September of 1992 and have been in private practice ever since. I have briefed and argued many cases in the Supreme Court of Maryland, as well as Maryland's second highest court, the Appellate Court of Maryland. I've had cases in the D.C. Court of Appeals and various other federal circuits as well. In 2019, I was appointed by the governor to the Appellate Nominating Commission, which interviews applicants and makes recommendations to the governor as to which judges to appoint to the appellate courts in Maryland. I am also one of the founding members of the Cole-Davidson Inns Court, whose aim is to improve both the quality and diversity of appellate practice in Maryland.
The first thing I want to say about appeals is something I used to have to explain to law enforcement officers when I was a prosecutor, and now have to explain to clients. An appeal is not a do-over of a trial. The appellate courtrooms in Richmond and Annapolis don't have a witness stand or a jury box. A court of appeals does not hear testimony. It does not determine the credibility of witnesses. Its review is limited to the law and the factual record that was presented to the trial court, exhibits, transcripts of testimony, and argument. On that limited record, a court of appeals does two things. On questions of law, it determines whether the trial judge committed some kind of legal error, and if so, whether that error was harmless or requires correction. And on questions of fact, it determines whether the fact finder, whether that was a jury or a judge, had enough evidence to support the conclusion it reached. The parties submit their arguments in written briefs, an initial brief by the party challenging what happened in the trial court, a response, and a reply. And then sometimes, but not always, the court decides to hear oral argument from counsel.
If you are the appellant, the burden is on you to demonstrate that the trial court erred in some manner. And as Stuart said, you do not get to introduce new evidence or raise new issues that were not presented in the trial court. But you can explain more fully the matters that were raised below. So while at trial, attorneys are focusing on all of the issues that are before the judge or jury, on appeal, you can really drill down to just a few of the legal issues, which of course allows you to get into those issues in much greater depth. And as Stuart relayed, you can raise error with respect to legal conclusions or factual conclusions, but given the different levels of review, your chances of success are much greater if you can identify legal error as opposed to focusing on the findings of fact.
Those errors are framed and identified for the appellate court in a written brief. So, what do we do to make our written arguments on behalf of our clients as persuasive as possible? Some points are obvious. Before you start to write, you have to know the trial court record and the applicable law inside out. You have to connect the law to the facts in a way that makes the judges care about your client's real-world problem. You have to write clear, crisp sentences in plain English without a lot of legalese. Good legal writing is punchy and compelling, not flashy or pretentious.
And probably the most important lesson that the two of us have learned after decades of writing appellate briefs is that you have to pick your issues very carefully. Some of the appeals that we handle, we have been trial counsel or someone in our firm has handled the trial, but frequently we are asked by outside counsel or clients to take over a case when it goes up on appeal, because appellate practice is really unique and different from trial practice. We have seen attorneys lacking appellate experience raise every possible issue on appeal, which is like throwing spaghetti against the wall and hoping that something sticks. But our experience has taught us that that is exactly the wrong approach. If you make judges slog through 6 or 8 or 10 unpersuasive arguments, you make them less likely to rule in your favor on the 1 or 2 arguments where you have the greatest chance of success.
Both of us can tell plenty of war stories, but there's one in particular that really illustrates that point. It's the story of my client, Brian Puckett. Brian got caught up in the real estate boom that preceded the great financial crisis. After the crash, U.S. attorneys' offices and law enforcement agencies set up mortgage fraud task forces and indicted every quote-unquote mortgage fraud case in sight. They indicted and convicted Brian in federal court for bank fraud relating to some loans that went bad. When Lerch took on Brian's appeal, we focused on the fact that the lenders weren't banks that were insured by the Federal Deposit Insurance Corporation. Instead, the lenders were separate corporations, mortgage lending subsidiaries that, at the time, didn't fall into any of the categories of financial institutions that were covered by the bank fraud law. There was no evidence that the FDIC-insured banks were affected at all by the loans. Now, there were plenty of other issues from the trial that could have been raised, but working closely with the client and with counsel for the co-defendant, we discarded those issues and decided to limit our briefs and oral presentation to arguing the best issue, the fact that the lenders weren't actually covered by the bank fraud law. The Sixth Circuit Court of Appeals agreed, it ruled in Brian's favor, and it reversed his conviction. Before we got involved, Brian was facing a prison sentence, a lengthy term of supervised release, and a huge forfeiture judgment. We cleared his record, we saved his career, and we kept his family together.
So, if you've suffered a setback in a federal or state court proceeding, consider whether you would benefit from a fresh set of eyes. And while we have done our share of overturning bad results from the trial court, we've also been contacted by outside counsel or parties when the other side is trying to undo a good result they obtained. And we also help them maintain the victories that were secured. We know how appeals work, and we know how to persuade the judges that hear them. Please feel free to reach out to Stuart or me if you have any questions about appeals. We'd be happy to help. And thanks for watching.